All rise to the President and Judge of the CARICOM Court of Justice.
Please take your seats.
Yes, I take it that the appearances in this matter are as before. Mr. Wood, would you like to continue with your submissions?
Honors, just as a matter of courtesy, may I take the opportunity to just introduce Mr. Joash Huggins, who sits immediately behind me, a new member of our chambers, and I invited him to attend today's proceedings so that he could witness the court in operation.
Yes, certainly.
Right.
Very well. Yes, proceed, Mr.
My Lord, thank you. I had made the point. I've broken down the matter into two questions for the court. And I had made the point that nowhere in the RTC is the word derogation used. We have spent some time in our written submissions at paragraphs 30 to 38 of the principal submissions in examining what is the meaning of the word derogation. And we have submitted that in the proper usage of that word, both in international law and in plain language as used by COTED, it could only mean a suspension of the treaty obligation, the suspension in this case being of the relevant CET tariff. The intervener, Rockard claimant, has brought to the attention of the court the protocol which amended Article 83 in 2015, which has supplied definitions of the words suspension or alteration as used in Article 83. And as defined, Article 83, subparagraph 9, defines a suspension. It makes the point that the suspension cannot be indefinite. It must be for a definite period of time, and the suspension can be given to allow a higher or a lower tariff rate as authorized by COTED. Alteration is also defined, and in the normal significance of that word, it means a change of the agreed rate of the CET, which is applicable to all states. So that amendment comports with the submissions that we have made. The protocol amended Article 83 specifies in Article 2 that it shall be provisionally applied upon signature of all parties to the RTC. The protocol has been signed by all the member states who are party to the RTC and is therefore provisionally in force. And in that regard, we rely on Article 25 of the Vienna Convention on the Interpretation of Treaties, which states that a treaty or a part thereof is applied provisionally pending its entry into force if A, the treaty itself so provides, or B, the negotiating states have in some other manner so agreed. So you will see that in Article 2 of the protocol, the member states have agreed that it should take force provisionally pending its formal ratification. And there should be no doubt of this, but paragraph 5 of the affidavit of Mrs. Bob Schaefer notes that Bahamas, and Montserrat are not parties to the RTC. So their signatures would not appear on the protocol. The members states who are party to the RTC are the 13 states reflected in the protocol who have signed. Now, in our written submissions, we have also made the point that the only power to alter or suspend the CET is set out and contained in Article 83. And we made the point at paragraph 34 of the written submissions that if what COTED did in giving derogation did not come within Article 83, it is ultra-virus. The terms conferring power to suspend a treaty has to be strictly construed, and we have amplified that in paragraph 41 of our written submissions, relying on the decision of the European Court in Miramax SPA versus Italian Finance Administration. And we also rely on the decision of this court in TCL versus the Caribbean Community, 2009 CCJ4, which is the only decision of this court that we have been able to locate to actually look at Article 83 and to construe it. We rely in particular on a statement made by the court in the TCL versus Caribbean Community case at paragraph 54 and paragraph 56, which set out the scope of the power to alter or suspend given in Article 83. And this is what the court said at paragraph 54, quote, "A distinction is to be made between a suspension of a rate and the alteration, that is, the increase or reduction of a rate. In relation to a final product, a rate is normally suspended when there is a temporary interruption of regional supply. Alteration of an established tariff rate is decided upon in circumstances where the relationship between production and supply of a particular commodity is of a more permanent nature. For example, where regional production has been discontinued, this will normally lead to a lowering of a rate. Or if new regional production comes on stream, that circumstance may result in the increase of a rate. Further support for recognizing a distinction between alteration and suspension of a rate may be gleaned from Article 83, which gives the Secretary General the authority between meetings of COTED to authorize a suspension, but not a reduction or any other alteration of a rate." And at paragraph 56, the court said, "Suspension of a rate is intended to be a temporary measure, and that authorization to suspend is granted only to a particular member state or member states in response to a specific request from that or those member states." So there the court clearly stated that a suspension of the CET could not be of a permanent, indefinite duration. It had to be a temporary measure. Now, following upon that decision of the court in 2009, the RTC Article 83 was amended in 2015. It is relevant to consider the reasons for that amendment. And that reason appears in the Jamaican ministry paper that we submitted this morning, ministry paper 128 of 15, which is tabled in the Jamaican Parliament and available both in the website of the Jamaica Parliament and indeed on the website of the Ministry of Finance. It was explained that the rationale for seeking the amendment appears at page 2. In November 2011, a legal opinion provided by the Office of CARICOM General Counsel, OGC, concluded that the ordinary meaning of paragraphs 1 and 2 of Article 83, when read in the context of other provisions of the revised treaty, and in accordance with the object and purposes of the CET, as set out by the Caribbean Court of Justice in TCL versus Caribbean Community, restricted the COTED in granting a suspension of the CET. The OCG argued that COTED's authority to alter or suspend CET rates was limited to the grounds set out in paragraph 2 of Article 83. The opinion noted that since those grounds were exhaustive and the existence of those grounds could only necessitate the lowering of a tariff or zero rating of a rate contained in the CET, it followed that paragraph 2 did not confer the authority to suspend the CET in order to temporarily increase the rate. After extensive discussion on the issue and given different views expressed on the correct interpretation of the CCJ's ruling in TCL versus Caribbean Community, the COTED at its 34th meeting in March 2011 agreed that Article 83 should be amended as a matter of urgency to allow member states the flexibility to adjust tariffs upwards or downwards in the context of their international obligations. So if we turn to Article 83, subparagraph 2, as existed before the amendment, you will see that it says, where A product is not being produced in the community, B, the quantity of the product being produced in the community does not satisfy the demand of the community, or C, the quality of the product being produced in the community is below the community standard, or a standard the use of which is authorized by COTED, COTED may decide to authorize the reduction or suspension of the common external tariff in respect of imports of that product, subject to such terms and conditions as it may decide, provided that in no case shall the product imported from third states be accorded more favorable treatment than similar products produced in the member state. So from the language that has been used in Article 83, it was clearly contemplated that a suspension would be resorted to reduce the tariff. And that is implicit as well in the circumstances set out in Article subparagraph 2, which must be in existence to warrant the grant of a suspension. Product is not being produced, quality of product produced does not satisfy demand, or the quality being produced is below community standard, etc. So we can see where counsel for the community was justified in advising that, as worded, Article 83, and particularly subparagraph 2, did not empower COTED to grant a suspension to permit a member state to increase their tariff on any particular item. It could, however, grant an alteration of the CET which would apply to all states. So viewed in this light, it does appear in my respectful submission that what COTED did in granting a derogation did not come within Article 83. It gave an indefinite suspension, which is contrary to the ruling of the court in the TCL case, and it granted a suspension to permit a single member state to increase a rate which was not in contemplation of Article 83, subparagraph 2, as existed in 2001. If this is correct, then the derogation could not have come within Article 83, and this is but an additional reason why there would be no support for any argument that COTED should approve the member state reverting to the RTC, or indeed requiring notification as a condition for the reversion. It is also significant, and I place emphasis on this, that the protocol amending Article 83 came into provisional effect in 2015, it having been signed by the state of Barbados in March, 11th of March 2014. The final signatory was Trinidad in January 2015. So when the state of Barbados decided to revert to the CET in the same year, October 2015, when the protocol came into effect, Barbados would have been well aware that what the COTED had done did not fall within the ambit of Article 83, as advised by the Office of the General Counsel for the Caribbean Community. So there could be no basis upon which it could be argued that the right to revert to the CET, which is the obligation of the member state under Article 82, is conditional on the COTED approval, nor can it be contended, I say this respectfully, nor can it be logically contended that the decision of a member state to apply the CET under Article 82 can be a breach of the obligation of Article 82, which is the obligation on the member state to establish and maintain the common external tariff. It's totally illogical to contend that the member state could in any way be in breach of Article 82 by simply doing what Article 82 requires it to do. So, my lords, I rely on the written submissions as the principal written submissions. What I've said this morning, excuse me, is in supplement to it. I think I also need to emphasize the point that has been made that the question of what is Barbados domestic law is completely irrelevant to this court if indeed the member state has the obligation to apply the CET under Article 82 of the RTC. I made this point because it was my perception when we argued the interim measures that the submissions of the state of Barbados that the CET had not been enacted into domestic law seemed to be a point that gained great traction at that time. And we have cited the European Convention on this, the Vienna Convention on this, and we have gone into some depth to make the point that as per Article 27 of the Vienna Convention, a party may not invoke the provisions of its internal law as justification for the failure to perform its treaty obligation. And that, we think, was also the thread of the reasoning in the Tomlinson case by this court and in the subsequent Whiteman case from the European Court, which dealt with the point of whether the United Kingdom, having notified of withdrawal from the European Treaty, would be required to obtain approval to withdraw its notification before that notification had actually crystallized. I emphasize there is no express provision in the RTC which precludes a member state from reverting to the CET after a suspension, or in this case, a derogation has been allowed by COTED. To impose such a condition, I submit, is contrary to the very wording, express terms of the RTC, Article 82, and it is also contrary to Article 83, which restricts the power of COTED or places the principal obligation on COTED, which is to secure uniform implementation of the CET. So one cannot simply write in those words into the RTC to create what is in effect a treaty obligation on the member state where no such obligation exists. And we have dealt with that in our reply, and we rely, among other things, on the reasoning in deep vein thrombosis. No matter how one wishes to get there, no matter how one thinks the objects are laudable, one has at the end of the day to apply the express terms of the RTC. One cannot write in obligations into the RTC to hold a member state liable for breach of its treaty obligations, which is what is sought to be done here. The TCL Arawak has relied on the decision of this court in the on the implied powers of COTED, and I submit that that case is completely distinguishable. It is a completely different thing to imply a power on an organ of the community for the purpose of it carrying out its function. But that is not what is being done here. One is trying to imply a treaty obligation on a member state to hold and condemn the member state for having breached Article 82 of the RTC. The court's decision cannot support that, and I suggest that the decision has no bearing on what the court, on the questions that the court is now asked to determine regarding the derogation issue.
Yes.
My Lord, unless I can be of further assistance.
Thank you, Mr. Wood. I think your arguments were very, very clear. Could I just ask one question, and that is that you are suggesting that there was no need for Barbados to go back to COTED to seek approval to revert to the CET. What do you say to the argument that even if there was not the requirement to seek approval, there was, or could be implied, a requirement to give reasonable notice, some sort of notice, that that was the intention of the state, because there are obviously going to be private sector entities who are arranging their business models and business procedures on the basis they perceive of a commitment to, from Barbados to charge the higher rate of 60%. So I'm asking whether you think there is any merit in the suggestion that even if approval is not required, at least some kind of notice, reasonable notice, that Barbados intended to revert to the CET.
The state may be castigated for its failure to follow a good administrative practice, but that cannot rise to the level of placing a condition precedent on the state to say that the state is precluded from reverting to its treaty obligation, which is to apply the CET. It cannot be a condition precedent. It may be a matter of good administration, and as this court has already stated in the same TCL Caribbean Community case in its conclusion at paragraph 81, the Secretary General's authorization of the suspension for Jamaica suffered from a procedural flaw, but for the reasons expressed, the court is content to issue the following declaration. So there may be a procedural flaw. It may be good and sound administration to enjoin the states to do this in future, but it cannot prevent them from applying their treaty obligation, and it cannot be used for the purpose of saying the state is in breach of the RTC because it has applied its treaty obligation without giving notification or obtaining approval.
You see, again, I follow you. The difficulty is that there could be an obligation to give notice, and if there was such an obligation, then in parallel with the doctrine of legitimate expectation, for example, it could be argued that private sector entities are entitled to that kind of notice so that they can arrange their business accordingly. So that is what I was hoping you would respond to. Not so much.
Legitimate expectation, in my respectful submission, the legitimate expectation of private sector organizations is to have the CET applied. There can be no legitimate expectation that flows where a member state goes to the COTED and says suspend for what occurred here an indefinite period. That does not create any legitimate expectation. Put it another way, you cannot have a legitimate expectation that overrides the law. And if the RTC Article 82 is the law, and under the law, the member state is obliged to implement and maintain the CET, no legitimate expectation can trump that. In the same way that no domestic legislation can trump that. If they have some grievance about legitimate expectation, that is maybe something for a domestic court to ponder on. But here we are concerned with rights and obligations created by the treaty, and Article 82 of the treaty is what governs.
I'm glad you referred to
Legitimate
the
expectation
distinction
cannot override.
between the domestic and the international courts, because it is the case that under domestic law, for example, there is a requirement that the treaty must be incorporated into national law before it can be the source of rights and obligations. That is the norm, that's the law. But surely we have instances where the treaty has not been so incorporated, and yet courts, including this one, have held that those treaties have given rise to legitimate expectation on the part of private individuals. So I don't think the possibility for legitimate expectation disappears because the state acts contrary to the norm. I do take your point that the locus for discussing that may be problematic, but of course we'll hear from the other side on this.
But then the issue becomes for the court, what is the norm? And if Article 82 is the norm, if Article 82 is the law that obligates member states to apply and maintain the CET, I repeat, a legitimate expectation cannot override that norm and that law.
Well, I understand your view. I don't think...
In the same way, in domestic law, I have argued the case, Ms. Mayhew was in it as well, where Parliament enacts a law, a prior legitimate expectation posed by the board. You cannot override a law by a legitimate expectation. And the law has to be applied by this court is Article 82 of the RTC.
It would be interesting to discuss the extent to which legitimate expectation applies in international law. That is something that perhaps we might be assisted on later. But I don't share the entirety of your submission at all because, like I said, the whole point of legitimate expectation is that it can override the norm. But be that as it may, I think I've received your submissions. I quite follow them.
At this point, Judge, this is not a legitimate expectation case. We are governed by the pleadings, and TCL's main relief that is sought, declaration number 1, is that the state of Barbados breached Article 82 of the RTC. With respect, that can't speak.
I follow your argument, yes.
So if you want to go and reformulate another claim, well, that is for another day.
Yes, and I'm not purporting to present their case for them at all. I'm just saying that might have been a legal basis for supporting the idea that there ought to have been reasonable notice given by the state of Barbados when it purported to revert from the purported derogation. But I understand perfectly what you're saying. I'm sorry?
Notice to whom? Because again, the correspondence will show you that TCL engaged the state of Barbados and was duly notified in correspondence with the minister that Barbados was reverting to the CET.
So are you then saying that in your view TCL had reasonable notice? Because if that's what you're saying, then that answers the question I was raising with you.
I believe there is correspondence exhibited saying that.
Wonderful.
So on them. But again, I'm making the point, and my primary point is that this cannot ground an argument that the state of Barbados breached Article 82. If TCL were to go and wants to go and reformulate its case, then that's another case.
Mm-hmm. All right, thank you, Counsel.
Okay. Can we hear, that's the conclusion of your submissions, I take it, Mr. Wood?
Yes, that was my submissions,
yes.
My Lord, and I think I've summarized the relief that we seek, which is in the reply, which is the the grant of declarations as sought by Rockard in paragraphs 1, 4 through 6 of its originating application, and of course the dismissal of the declaration sought by TCL that the state of Barbados breached the RTC Article 82 when it reverted to the CET in 2015.
Yes, we have that. Yes. Thank you very much. Maybe hear now from the state of Barbados.
Yes, Your Honor. May I please support the state of Barbados had filed a written submission in respect of the order made on the 14th of January 2019 to deal with the issue of derogation. We respectfully stand by the submissions we made and would just like to highlight, if it's acceptable to the court, areas and submissions that we made in these written submissions. First of all, we have submitted that in the revised Treaty of Chaguaramas, Article 82 provides for the establishment of the Common External Tariff, and Article 83 provides for the operation of the Common External Tariff, putting any alteration or suspension of the tariff to be decided by the Council for Trade and Economic Development. It is the position of the state of Barbados that under certain circumstances, a member state who has been granted a derogation from the Common External Tariff would not need to go back to COTED if it wishes to reapply the Common External Tariff. And as can be seen
Counsel, just to clarify matters, when you use the term derogation, as you just did, what exactly are you referring to? Alteration and or suspension or something else?
I'm referring to the alteration or suspension,
okay.
i.e., if the...
Yeah, thanks.
But is it an alteration or a suspension?
Well, Your Honor, it would be an alteration if the rate that is now being requested is a rate that is either higher or lower than the Common External Tariff. It would be a suspension if the rate is for a specific time limit.
Based on what Mr. Wood argued earlier, would you agree that if it was a suspension, it would be a reduction? Because that seems to be the purport of Article 83 too. If you read...
Suspension if it's...
Yes. But I'm not sure that needs to detain us. I'm just trying to establish that you're not thinking of a third category aside from suspension or alteration. When you say derogation, you're thinking of either suspension or an alteration. I see.
Which would reflect in a rate that is different from the CET.
Yes.
Yeah, but that doesn't make much sense because an alteration of the CET means if it's now 15%, then an alteration would be that it's 20% or 10%. CET is something common, a common external tariff. It's now 15% or 5%, and you can change that, alter it. So anything else would be a suspension, I would think. Now, whether a suspension is only possible if you reduce or not, that's another issue. But in my view, I would not be able to understand this as an alteration of the CET. That would be an alteration of a common external tariff, and that is not, because this is just something specific for Barbados.
Correct. Barbados. Yes, Your Honor.
So it would seem to be a suspension.
Well, it's going to be difficult if it's a suspension, in the sense that it doesn't seem to be a lowering that Barbados asked for. It seems to be a significant increase in the rate. So is it what Mr. Wood is saying, that this event was not authorized at all by the RTC?
Well, my Lord, we also had submitted submissions to the effect that the cement that is the subject matter and issue here was not part of the request made in 2001, where we did submit respectfully that other hydraulic cement was not included in this derogation request.
Yes, but is that not a different issue altogether? In other words, for those items that were included, whatever they were, the question is was that a legitimate decision taken by COTED, having regard to the fact that, based on what my brother said, it could not have been an alteration, it wasn't applicable to all states, and it might not have been a suspension either, because really it seems to have been geared towards a higher rate, and more particularly, it wasn't for a specific time. So it seems to have been neither fish nor fowl.
Well, my Lord, we recognize that the decision given by COTED, we recognize that it was not given for a specific time limit. We also recognize that for those range of manufactured products that were submitted in the request, the percentage was definitely an increase to the common external tariff.
Right.
Because at the time, in the list, what is described under the types of cement, the column for CET had 15%, and the proposed request was for 60%. So the state of Barbados, in relation to those lists of manufactured products that were submitted to COTED, was definitely I concede that common external tariff is something that applies to all member states. This was for 60%, and it would apply specifically to Barbados.
Yep. So we have an unresolved problem, because we are trying to locate it in the RTC, and perhaps as we go forward we might have further luck, but so far it seems difficult to locate it either as a suspension or as an alteration.
We have put forward a submission that,
No, it's not only, that's right, what it means.
as it was something which was open-ended, if the state of Barbados wished to apply or reapply the CET with those manufactured goods, it would have to go back to COTED. And that is because this rate of duty would affect business entities amongst the member states. And as such, we believe COTED would have wished to have their input, just as it had their input and views when it was looking at the granting of the derogation request. we've also submitted that if the derogation granted was for a specific period, then there would have been no need for the state of Barbados to go back in relation to any of these manufactured products, because the derogation would have automatically expired as a result of effluxion of
Suspension.
suspension. We also have submitted respectfully that if in relation to this derogation, the member state wished to reapply the CET before the specific period, they would also have to go back to COTED. We have seen the submissions made by the Caribbean community in relation to the derogation aspect, whether or not you have to go to COTED. And we believe that it does agree with us with some of our submissions. It does point out that there will be interests of other parties other than the member state who intends to revert to the CET, that COTED would wish to hear from them, and that notification would not be enough. And as far as the list of manufactured products that was presented to COTED in 2001, we believe that the state of Barbados would have to go back to COTED insofar as it was open-ended, and that third parties would be affected by a decision to revert back to the CET.
So the state of Barbados will be internationally liable if it was found that other hydraulic cement was included expressly or otherwise in the 2001 request. Is that what you're arguing?
No, Your Honor, I don't think we would want to be arguing that position.
I don't think so.
We have put in our defense that as far as the state of Barbados is concerned, it has not breached the RTC.
Yes, but the reason you're giving for not breaching the RTC is that the request did not include other hydraulic cement. Is that so?
Well, that's one of the reasons that it did not include other hydraulic cement.
So if there's a
and we have,
I'm sorry.
Sorry, and we have submitted certain reasons for that in our submissions. We have pointed out that at the time the request was made, and when one looks at the list of the manufactured items, it speaks of a 15%, and that the CET at that time would not have been 15%, at least in relation to other hydraulic cement. And we've also pointed out that Barbados has always applied a 5% duty for other hydraulic cement. And that has been in place when it was first introduced to the country for importation in 2015.
Yes, is there anything else?
No, Your Honors, I would refer to our written submissions in relation to the scope of the derogation, and unless I could be of any further assistance.
Yes, thank you very much.
Thank you.
So, do I understand you correctly that Now you're saying, okay, we never asked for suspension or whatever for other hydraulic cements. But if the court would come to the conclusion that you did, in that case, then you acknowledge that Barbados was in violation because you did not ask for an approval of COTED to revert back to the CET in that particular case. Now, I know that's not your submission, but but that is what you're saying. So you would agree that if other hydraulic cements would have fallen under your request for an authorization to suspend the CET and to make it 60%, if we would come to that conclusion, then you are saying, okay, then Barbados was wrong because we did not ask for approval of COTED to go back to the CET. Is that correct?
Your Honor, I think what I'm trying to say in this submission is that the court is asking whether if in the event that the court finds that other hydraulic cement was included in the list of documents requested for derogation,
yes,
and the state of Barbados has applied the CET rate without going back to COTED, whether this is in breach of international obligation. Is that the
yes, that's the question.
question?
In fact, I think
Yes.
that is what you said. You said the state, if it wants to revert to the CET, while it got authorization to increase the tariff, in that case the state needs to go to COTED to ask for approval, or at least to notify. That is what we did not do. And you're saying then, okay, it was not necessary to do that because we never asked for and never got authorization for increasing the tariff on other hydraulic. But if in case we would disagree with you on that last point, then you are saying that we were wrong.
Yes.
Correct?
Your Honor, is this something that should be perhaps dealt with in the substantive hearing of the matter as opposed
This
to
is it.
Well, this point
issue with
is now
derogation?
very substantive at the moment. So we're hearing you. This is not a procedural thing. This is very substantive debate about these issues that are before us now.
Yes. I sought to ask you the very same question a little earlier. And what occurred to me is that, and please correct me if I'm wrong, I don't think I am, Barbados is making very principled submissions. First of all, on the question of the need to go back to COTED. And you have made those very principled submissions, and you've made other submissions about the scope of the request that was made in 2001. I think both Justice Witt and myself are simply pointing out the implications of those submissions. But I think we have them just very, very clearly. So I'm prepared to proceed on the basis of the clarity that you have provided.
Well, Counsel, I am very sorry to stick out like a sore thumb, but clarity is not with me because I'm not sure what it is you are saying is the position of the state of Barbados if in fact there was a derogation obtained by Barbados in favor of other hydraulic cement. And the question which was asked of the parties was whether a member state that has obtained a derogation is required to obtain the approval in order to reimpose the CET. I am looking at the order, and I will confess I looked at it 3 times because I knew I had it wrong somewhere, but apparently I don't. So you need to tell me what is the position, the submission of the state of Barbados on that question. Does a member state which has obtained a derogation, is that state required to obtain the approval of the CET in order to reimpose, of COTED, in order to reimpose the CET?
Yes, Your Honor. I believe Barbados' position would be is that if the derogation granted is open-ended, no specific time limit given, then the state would have to go back to COTED to reimpose.
You have answered my question. Thank you very much. That was great clarity. Thanks.
Yes. Okay, that's the extent of your submissions.
Yes, Your Honor.
Yes.
And they're very principled. Thank you very much.
Okay. Should we hear now from TCL?
Thank you very much, Your Honors. TCL and Arawak.
And Arawak.
Yes. Your Honors, I believe I should, in my summary oral submission, begin really where the discourse between the court and the representative of Barbados left off, which is to remind ourselves what is the issue that the court, by its order of the 14th of January, asked us to address the court on. And on that order, which is the order of the 14th of January, 2019, written submissions were required on the issue of whether a member state that has obtained a derogation from the Council for Trade and Economic Development to increase an applicable tariff to a rate beyond the common external tariff is required to obtain the approval of COTED in order to impose the common external tariff rate. And I
Have we lost Mr. Wood? Oh, Ms. Bob Schaefer? Are you hearing us, Ms. Bob Schaefer? We're seeing you but not hearing you. Okay, it seems as though you have a problem with your audio.
Please enter the conference PIN number. Welcome to the conference.
Are you hearing us now, Ms. Bob Schaefer?
Yes, Your Honor.
Okay, good. Yes, Mr. Amor.
thank you, Your Honors. I believe in reading the order, I said in order to impose, but it is in order to reimpose the common external tariff rate. And I begin there deliberately because I will confess that I became a bit concerned in listening to Mr. Wood's principal submissions, oral submissions today, in allowing myself to think that we were addressing another question entirely, but I'll return to that. I think that what I would like to emphasize, Your Honors, is merely by way of a summary of what we have already submitted, and we have submitted quite significantly in our written submissions, which are with the court. Those were filed on the 28th of January and the 1st of February 2019 in answer to this particular issue which the court has identified for us. And in emphasizing those submissions, I would simply emphasize the point that We are, as the decisions of this court has reminded us, we are dealing with a common external tariff that is applicable to all of the members of the community. And I would emphasize the point, firstly, that even though what was applied for by Barbados in 2001 was a derogation for Barbados of the 60%, we cannot escape from the fact that that derogation, once approved by CARICOM, had and has and continues to have implications for all of the member states, all entities who are relying on the fact that the common external tariff was approved by way of the derogation in 2001 to operate at 60%. And our principal submission is that if that common external tariff or that tariff is going to be adjusted or otherwise changed, then we submit respectfully that the state of Barbados would have to return to COTED to get that adjustment approved. And I believe that we find common ground in that regard in the submissions that have been filed with respect to the issue. The claimants, defendant, and CARICOM all agree that a member state ought to return to COTED. I think we have common ground on that, subject to what Mr. Wood said today, which I think is addressing a different issue. Where CARICOM and ourselves differ is to the extent that CARICOM would suggest that it is enough simply to inform, and there doesn't necessarily have to be a formal application for approval. It is our submission, Your Honors, that at the end of the day, the main reason why we submit that a member state must be required to return to COTED, and therefore why the intervener is incorrect, is that the common external tariff is intended to underlie a functioning single market, the CSME. And we spell that out in paragraph 15 of our written submission of the 28th of January 2019. Because those decisions concern what any one member state's market applies in respect of all members of CARICOM. So where a member state has increased a tariff rate, that increased tariff rate has implications for all other members of the single market. So that where that member state proposes to reduce the tariff rate back to what it was originally, all other member states, in our respectful submission, within the contemplation and the sensible construction of the RTC, all other member states must be allowed an input into that decision. And it is why we say, therefore, that there has to be a return to COTED so that that process and the sensible interpretation of the RTC can be allowed to operate.
So you are saying then that other states could say no?
Indeed, yes. They may give reasons why they think it is not appropriate, or they may give reasons why it is appropriate. But ultimately, the input of other member states on a sensible interpretation of the RTC would require a return to COTED.
Because the obligation is to establish and maintain a common external tariff, yes, which they did, let's say 15% or 5. And then Article 83 then gives COTED the power to authorize a state to deviate, yes, from that CET. After getting that authorization, the state might rethink things and say, well, you know, I got the authorization, but I don't think I need it, so I will continue to maintain the CET. One would think, because states have sovereignty, and they didn't give away all their sovereignty, even in this respect. The only thing they cannot do is deviate from the CET just like that. When before they became part of this club, so to speak, they could do that. Now they can't do that. They need to have the authorization of this organ of the community. But the main obligation is still to maintain the CET.
The main obligation is to maintain the CET honors. But, well, not but, and we submit that it cannot be ignored in the particular facts of this case. We have a situation in which the common external tariff, a derogation was applied for and granted in 2001. In 2015, a considerable period of time having elapsed, it is not either a reasonable or sensible interpretation of the RTC, or indeed, if one were to borrow the phrase legitimate expectation, and I don't want to go there, but it is not a reasonable procedure to thereafter revert from the 60% to any other rate without the opportunity of going back to COTED, so that other states and members of the business community who operate in those states can have an opportunity to make an input through their sovereign state partners.
And also have an opportunity, in your view, to say no to the state.
Indeed.
Yeah. And that is quite different from an obligation to go to COTED and notify, so that everybody now will know within 1 or 2 months the tariff will go back to
but
what
at least
is
the
CET.
notification gives parties some reasonable time within which to make the appropriate adjustments.
Clear.
Yes.
But there is quite a difference between really being dependent on the approval now to go back to the CET, on the approval of COTED, other states, or just to notify them, give them a reasonable notice. The effect of both is quite different. You would agree?
What we say, Your Honor, is that the framework of the RCT is a community-based framework, and ultimately it cannot be for a unilateral decision of one member state to resile from an approved course of action which COTED had previously approved, simply by resiling from the approved course of action. So we think that to the extent that what is being contended for by the intervener in particular is a unilateral course of action without any recourse whatever to the mechanisms contemplated within the RTC to go back to COTED, we think that that is an incorrect application of the spirit and intent of the RTC.
But the course of action that you referred to assumes that that is a legitimate course of action. It's a course of action within the powers of COTED. And so far, I don't think you have interacted frontally with the view put forward by Mr. Wood. If I understand him correctly, what he's saying is that whatever COTED may have done in 2001 cannot be housed within the four corners of the RTC. It is an illegitimate, unlawful, ultra vires action, and therefore doesn't result in a proper course of action that you were just speaking about. Now, basically, I understand him further to be saying that there's nothing in the RTC that refers to a derogation. So that you must be speaking about a suspension or an alteration. But what Barbados got in 2001 was neither of those two things, and therefore Barbados got in 2001 did not fall within the corners of the RTC. How do you respond to his argument?
Well, I respond to that in a number of different ways, Your Honor. And I respond, first of all, by reminding the court of where I began, and that is by going to the issue which the court has identified for us to address. And the issue which the court has identified for us to address is a statement of an issue premised on the fact that a derogation has occurred, and what is the procedure that a member state where the derogation has occurred must employ if it wishes to reimpose a tariff which previously existed. And we have addressed that in our written submissions. Significantly, in our written submission, and that is a written submission of the 28th of January, at paragraphs 19 through to 21, we had addressed the question that Barbados had intended to, or it was not for the intervener to say what the respondent state's intention was at the time that it had approached COTED, and we referred at paragraph 20 to the 60% rate which has been in operation since 2001 to 2015. At 21 of our submission, we had said, however, without prejudice to the foregoing, the claimants submit that even if the 2001 derogation obtained by Barbados were to be treated as a suspension, Barbados would still have been required to return to COTED, where the period of time had not been decided upon by COTED, so that you now have Barbados having to return in order to bring that period to an end. Mr. Wood's submissions, written submissions, when you look at them, at paragraphs 35, 38, and 41 in particular, have assumed that Barbados had applied for a suspension. That is why I say that I was taken aback this morning when, in fact, he started on the basis that what has been done is ultra-virus and is not a suspension. If you look at paragraph 38 of the intervener's submissions of the 21st of January, paragraph 38 says the derogation that was granted by COTED can only be understood as a grant of suspension of the CET in respect of the listed items under the power contained in Article 83. He continued at paragraph 48.6. He talked about, this is on page 3569 of 3572. The derogation granted by COTED to Barbados in May 21 can only be understood as a suspension in the application of the CET in respect of the listed items. So I am taken by surprise to have him now say that what he's arguing is not a derogation, not a suspension at all, but an ultra-virus derogation. And my answer to that is that we are saying that whether or not what occurred in 2001 was a derogation strictly allowed within the language of the RTC, we would rely on the common external tariff, we would rely on the role and function of COTED and the implied powers that COTED must be understood to have in the application of the RTC to have permitted the derogation, which was permitted in 2001, and to the extent that that derogation was permitted, we say if that derogation is now to be departed from, we having relied on it, all parties having relied on it for the period that they have, there must be a return to COTED, at least to inform of the fact that that reliance is going to be altered and changed. And I'm reminded to refer the court to paragraph 16, page 3662 of our submission.
But would you agree, though, and this is why I was hoping that we'd speak in terms of the language used by the treaty rather than derogation, but would you agree that if we're talking about a suspension, it would have been necessary for a specific time to have been given?
Well, to the extent that the protocol which was amended in 2015 has defined the terms of suspension and alteration. Hindsight is 20/20 vision. We can look at the definition of suspension in 2015 and say, well, yes, a time frame must have had to have been contemplated for there to have been a suspension within the context of the suspension meaning given in the 2015. But at the point in 2001, that articulated definition of suspension did not exist.
Yes.
It is accepted that no time frame was granted, and we've made the point in our submissions that it was an inordinate period of time. Why we say, in fact, it could not have been a suspension, but be that as it may, the fact is that what was approved in 2001 by COTED was approved by COTED, we say, within the contemplation of the powers. And if I just remind the Court, Your Honours, page 3662 of
as it will.
Just a minute, Mr. Wood, your mic is still on, so we are hearing you.
No, we didn't want him to go entirely.
Are you still there?
Disconnected altogether.
Ouch.
We'll have to wait until he gets back.
How to silence somebody.
Mr. Amo, there was something I wanted to raise with you.
Yes, that's okay, Mr. Wood.
Yes. But,
I am technologically challenged.
But not otherwise, we see. Wonderful.
just using Mr. Wood's language of going back to the norm, I'm still sort of trying to come to terms with why you were arguing that one would have to go back to the member state COTED for approval, and why other member states would have a say in something like that if you were returning to the CET, which is the norm.
Because what was created, Your Honor, was an expectation, given the derogation that was approved in 2001. We are saying, however you phrase it, whether a derogation, a suspension, an alteration, we interpret what was done within the four corners of the RTC on a sensible construction as an order that was made on which we have relied, and to the extent that that is going to be altered as a community tariff applicable to and affecting all members of the community and entities within the community, we would expect that in the normal course of the tariffs application, the RTC sensible construction, there would have to be a return to COTED. If you use the language of the CARICOM simply to inform, or as we submit for approval, in any event, there ought to be a return. Paragraph 56 of the CARICOM, TCL CARICOM decision, which we cite, talks about the fact that the court holds that Article 83(2)(b) must be interpreted in a sensible manner. We rely on that. We say that the sensible construction of the revised Treaty of Chaguaramas would require there to be a consistency of action by member states.
You know, Mr. Amor, I want to take you back to the question I was asking earlier about the suspension and whether, in fact, what occurred in 2001 fell within the contemplation of the treaty. Now, you have answered me in relation to the time period. You have said that the requirement for there to be a specific period of time was introduced in 2015.
Yes.
And that protocol operated provisionally from that day, well, from when it was signed by the member states onwards. But could I ask you another question about the suspension? Because if you look at Article 83, it mentions the fact that COTED may authorize the reduction or suspension. But the context in which COTED may do that, if you were to read A, B, and C, would suggest a lowering of the CET in order to encourage the importation of extra-regional goods. So the suspension that Article 83(2) seems to be contemplating is a reduction, and I'm happy to receive your submissions on the point, in the CET. In fact, it says authorize the reduction or suspension. Now, if you look at the paragraph before that, paragraph 1, says any alteration or suspension of the CET. Right? So 2 is simply speaking about suspension. And if you read that in the context of A, B, and C, it would seem to be that the suspension is anticipating a lowering, reduction. of the CET. Now, to the extent...
Or a zero rating.
Or a zero rating, indeed, yes. Thank you, President. So to the extent that that makes sense, does that not reflect then on the validity of what was done in 2001? That is to say that that could not have been characterized as a suspension?
Read literally, Your Honors, yes, but I revert once more to the point that I've made before, at the risk of repetition, that ultimately we have to apply the RTC in a sensible manner to preserve community rates that the member states are able to rely on and the entities trading within those member states are able to rely on. And if what was done in 2001 was approved by COTED and continued to be relied on over the 15 or 14 years that it has been applicable, then we question whether at this stage this court could be asked to declare that what was done was so ultra-virus so as to have rendered a nullity everything that has been relied on up until this point in time.
Mr. Wood said your client had noticed that Barbados intended to revert to...
That is, I'm happy you've raised that, Your Honor. That is not correct. When you read the language of the correspondence, and I was very recently going through it again, when you read the language of the correspondence that is attached to our originating application, the correspondence begins at the stage at which there appeared in 2015 a newspaper report of a fait accompli that was already in the news, and my clients began to write to the Barbados government, Senator Donville Innes. All of the correspondence is consistent. And the persons who wrote on behalf of my clients at the time were Queen's Counsel Ralph Thorne and Queen's Counsel, there were two Queen's Counsel, two Barbados Queen's Counsel. The correspondence is all there. And what they were complaining about in very clear language is that the state of Barbados has taken us by surprise in visiting on us a fait accompli without any prior notification to us. Correspondence is very consistent throughout. So much so that the permanent secretary, and I can pull that up for your honors if you wish further assistance, so much so that the permanent secretary wrote back at one stage to Mr. Thorne to say that they would have to investigate the circumstances. None of the correspondence demonstrates any engagement by the state of Barbados before the decision was announced, and the terms in which it was announced by Mr. Donville Innes were to the effect that Barbados had taken the decision to create a level playing field and that the 60% had lasted for too long. So he was speaking after the fact of the decision having already
And just remind me, when was that again? Was that 2000?
That was, if your honors permit me, the decision was on the permanent secretary's correspondence was October 2015,
Right.
and the correspondence, our originating application, 0812, it begins from 0812, the correspondence, on page 414 of 417.
So that was 2015.
2015.
And we are now in...
2019.
So if Barbados needed to go back to COTED to notify, in the words of CARICOM, their decision to revert, and your client had notice in some way, shape or form in 2015, 4 years ago, don't you think it's time that Barbados should be able to revert to the CET if it wishes?
Well, to answer that question in a vacuum, Your Honor, would be difficult. The point is that we were challenging the fact that we wanted to meet with Barbados on the correspondence. I'm just trying to pull up, Your Honor, permit me 1 minute.
You see, sorry, I understand where you're going, but the point is this, that I sort of, made mention of the idea of reasonable notice, that even if there was no requirement, could be argued. CARICOM says notification, that's a reasonable notification. But surely, if you had notification in 2015, you know, come on, this is 2019. So surely you must be aware that Barbados wants to go back to the CET.
We were aware, Your Honors, at October 8th, the decision was made. I'm looking at correspondence. What is the number of that? Correspondence dated November 16th, 2018, 2015, which is at page 416 of 417. So from that date, we were aware that a decision had been taken by Barbados, which we had no previous input into. And from that date to now, we have been seeking to engage with Barbados, and the correspondence is there to say we would like an input, we would like to engage in conversations, in discussions, and we've had no response from them. In fact, there is correspondence that we've attached to show that for a considerable period of time, there was no response to us at all. Yes. All attached to our originating summons.
I understand that, and you know, I think comments may be made about that, perhaps in a different forum. But if CARICOM is correct, that all they needed to do was to have gone back and notified, you know, COTED, then you could see where I'm going. That in effect, not perhaps procedurally correct, in effect, you have had notice now for 4 years. And Barbados is not required, a la the submissions of CARICOM, to give effect to the wishes of your clients. I'm sure that's one of the things that Barbados would consider, but it's not obliged to do that.
But the point is, Your Honor, is that over the period of time that my clients will have relied on the course of action that they were led to understand applied, they have made investment decisions, they have made commitments, and these things can't be reversed overnight. And therefore, all that that my clients have been seeking to engage the state of Barbados in over those years is to say, can we please sit down and have a conversation that will address the substantial investments which we have made over a substantial period of time that cannot be reversed overnight without significant loss to us.
I understand the commercial aspects of it, I do.
So we say, Your Honors, that there is, in our respectful view, an implied power vested in the RTC that would require the state of Barbados to have returned to COTED to get the approval, and at the very least, if we adopt the submissions of the CARICOM Secretariat, to inform, and that was done only very recently, and we say in relation to the second issue that the court has asked us to address on, and that is by the order of the 1st of February 2019, and that is the question of the other hydraulic cement. We say that the heading was significant, 4 digits that encapsulates the 6-digit numbers, other hydraulic cement, and in fact we're very grateful to CARICOM to have shown us in CC3, I believe it is, to their most recent submission, that as far back as 2009, I believe it was, CARICOM, 2001, there was in existence the, if you just permit me 1 minute to locate that document. There was in existence, CARICOM has put it in its page 3917 of 3922. Is that what I mean? CC1, 3923. Is that the correct one? Sorry, Your Honors, the technology is getting ahead of me. It's 3989 CC3. We see very critically CARICOM has given us the benefit of the 1996 Harmonized Commodity Description and Coding System, where we can see at the bottom of page 3991, the heading 2523 Portland Cement, etc., and the subheading 6 digits 2523.90 other hydraulic cements, which is included, we submit, in the heading which Barbados took to CARICOM in 2001 and got approval to take the CET up to 60% for. And therefore we submit that other hydraulic cements falls within the larger approval that was given for the general heading. And we rely as well on the fact that subsequent to that, Barbados passed domestic subsidiary legislation in the customs tariff orders that has created a domestic regime on which our clients have relied.
Yes. Is that it, Mr. Amo?
In a nutshell, that's it, Your Honor.
Yes. Okay. Thank you.
As I can be of any further assistance.
Yes. CARICOM? Ms. Bob Schaefer, are you there?
Yes, yes, Your Honor. May it please, Your Honor, I would first like to begin where my learned friend from TCL has left off, and then turn to the issue of whether approval is necessary. The facts in this case are simple. In 2001, COTED granted Barbados a derogation to allow the application of a rate of 60% in relation to the goods that comprise the HS heading 2523. Heading 2523, according to the HS nomenclature 1996 second edition, which my learned friend has just referred to, at page 3991 in the bundle of TTOJ2018 /002 or 631 of the bundle in BBOJ2018-01. So according to this second edition, the heading comprises Portland cement, alumina cement, slag cement, supersulfate cement, and similar hydraulic cements, whether or not colored or in the form of clinkers. The subheadings, so the subheadings to 2523, which are important trade products included in the heading HS 2523, are as follows. So 2523.10, Portland cement, 2523.21, white cement, 2523.30, alumina cement, and 2523.19, other hydraulic cements. While the words other hydraulic cements do not appear in the heading, they appear in the subheadings of heading HS 2523. The issue which therefore arises on the facts is whether the derogation which Barbados obtained in relation to heading HS 2523 extends to the subheadings of HS 2523. And what Barbados applied for was Portland cement, cement fondue, which is the same thing as alumina cement, slag cement, supersulfate cement, and similar hydraulic cements. So what is the applicable rule governing this matter? The CARICOM community respectfully submits that the applicable rule is that goods which are classified under an HS subheading are within the scope of the corresponding heading. As the HS classification handbook states, and you can find this at page 61, page 618 of the bundle BBOJ, or 3978 TTOJ 2018-002. And it says there that the harmonized system is a structured nomenclature comprising a series of 4-digit headings, most of which are further subdivided into 5 and 6-digit subheadings. The structure reflects the manner in which the system was developed. First, by the deliberate creation of 4-digit headings to accommodate particular groupings of related products, so for digit headings like 25, 23, and second, by the subdivision of these headings, aluminum cement, other hydraulic cement, by the subdivision of these headings to provide separate treatment for the more important products included in the headings. And this is very important, that the goods which are classified under the subheadings are regarded as goods that are included in the headings. Thus, goods classified under an HS subheading are included in the headings. So let us apply this rule to the facts before us. Applying the rule to the facts of the case, it is respectfully submitted that other hydraulic cement, being a good classified under subheading HS 252390, is within the scope of HS 2523. This is because the state of Barbados obtained a derogation in relation to the goods comprising heading 2523. Other hydraulic cement is a subheading of heading 2523. Accordingly, Barbados obtained a derogation in relation to other hydraulic cement. As lawyers, we often reason deductively. So I am going to reason in this way. So the Caribbean community respectfully submits that, and this is the syllogism, all goods comprising the subheadings of a heading of the HS are included in that heading. Other hydraulic cement is a good comprising a subheading of HS 2523. Therefore, other hydraulic cement is included in HS 2523. Otherwise put, a derogation in relation to goods comprising the entire heading of the HS includes a derogation in relation to goods classified under the subheadings of that heading. The state of Barbados obtained a derogation in relation to the entire heading HS 2523 except for white Portland cement. Accordingly, the state of Barbados obtained a derogation in relation to the goods classified under subheadings of HS 2523, with the exception only of white Portland cement. Thus, the state of Barbados, in obtaining a derogation in relation to heading HS 2523, obtained a derogation in relation to subheading HS 252390, which is other hydraulic cement. In other words, referring to what Barbados specifically asked for in obtaining a derogation in relation to Portland cement, cement fondue, slag cement.
Yes, I think we got it now, Ms. Babshefa. Now the question is, the question is now, yes. Ms. Babshefa, is that derogation still extant? Did it come to an end? When did it come to an end? Is it lawful?
Yes, it is, and if Your Honor will give me a few minutes, it will complete just a little more on the scope of the derogation and turn to approval.
Yes, but before GC, before you do that, just to ask two very small questions on the scope.
Yes.
You have referred twice now to submissions by the Caribbean community. Is that deliberate, or because I gather Barbados does not share, on this point anyway, the submissions you're making? So are these the submissions of the community or the submissions of the Office of General Counsel? I'm sorry?
So submissions on behalf of the community, and as I can indicate, and as Your Honors have in the report of COTED, Barbados trade, speaking about Barbados legal, Barbados trade at the 77th session of the COTED held on the 28th of January took the floor and reminded COTED that it has a derogation in relation, since 2001, in relation to both Portland cement and other hydraulic cement, and that the rate is 60%.
Okay, thank you. I hear you. The other question I want to ask is one asked by my brother earlier, Justice Witt, when he asked counsel about the question of authorization. So COTED authorized Barbados to act pursuant to this derogation. What do you understand that term to mean, that Barbados was authorized to act a la the derogation?
So Barbados was authorized to apply a rate of 60% instead of the common external tariff. While I'm not absolutely sure, since I'm still searching for the documents, Article 146 of the treaty provides for derogation in relation to disadvantaged sectors, and Barbados, in applying for the derogation, had pointed out on page 49 of the bundle of the need to provide its manufacturing sector currently under
General Counsel, I think we get that point, but the point I'm trying to raise with you, the one raised by my brother earlier, relates to the word authorization. In other words, it is not mandatory for Barbados to act pursuant to the derogation. Barbados is authorized. So we're trying to get from you what the position is as regards that concept.
Okay, so trade liberalization and the maintenance of the CET is a fundamental principle of community law. It follows, therefore, that the principle of proportionality applies, and Barbados should only use a derogation to the extent that it is strictly necessary. So if it is not strictly necessary, then Barbados should terminate the derogation and inform COTED. It doesn't have to be before, but inform COTED, because the information is important to COTED so that it can carry out its functions under the revised treaty to continuously review the impact of the CET. So if COTED is unaware that another member state has reverted to the CET, it doesn't have the requisite information in order to come to a sound conclusion as to the impact of the CET.
Right. Now, so to move from 60% back to, is it 5%, notification is required. Just as a matter of interest, could Barbados have moved from, say, 60% to 30% with or without notification? Or is just between 60 and 5%? Those are the two variables.
Your Honor, I think it is between 60% and the 60% or CET, because they were not granted a derogation up to 60%,
yes,
but they were granted a derogation at the rate of 60%.
Yes, I follow. And finally, I'd raise the issue of reasonable notification. Now, you say that Barbados simply has to come back to COTED and notify. Do you think that the concept of reasonable notification is a useful one in this context, bearing in mind the submissions by Mr. Armour about the reliance of business entities on the derogation?
Reasonable notification is perhaps desirable, but reasonable notification must give way to the principle of proportionality, which is that you can only apply measures that are strictly necessary. The principle of proportionality trumps reasonable notice, because if a member state has made an informed decision that it no longer needs a derogation, it should not continue to to maintain this derogation because it now has to give notice. And if I may go further, this case.
What about the businesses that rely on the derogation?
Yes, well, if a member state is of the view that the derogation is no longer necessary, then it means that the businesses don't need the derogation. They may want for their own interests. But if a member state has looked at the manufacturing sector and has come to the conclusion that the derogation is no longer necessary, it should not be bound, hamstrung by reasonable notice. And if I may want to make an important point before I forget, approval could never be the law. Initially,
yes, with respect, let's not go there because we follow your submissions. I'm still interested in the concept of reasonable notice because, I mean, after all, the CSM is built around the private sector. The preamble speaks about the CSME being private sector driven. Are you saying that the government should act complete isolation from business concerns, commercial concerns?
No, Your Honor. Indeed, in informing COTED that informing COTED that it is going back or it has just gone back to the CET. It's providing businesses with legal certainty. It's providing businesses with
yes, but if the
state
comes to COTED GC today and tells COTED, look, I'm going back to the CET tomorrow, that doesn't give the businesses much time to adjust, does it?
But that's okay because under Article 146, where a member state may have a derogation in relation to the rights and obligations under the treaty, it provides in that instance that COTED shall periodically examine the impact of the measures mentioned in paragraph 2 with a view to determining their adequacy and establishing a time frame for their continuance. If this matter goes before COTED, if COTED carries out its role as a monitoring mechanism to see whether the derogation is still necessary, COTED should not now have to wait and give 1 year, 2 year, 3 year notice to business persons. So COTED can make a decision and decide that they're no longer reviewing and make a decision that there's no need for the derogation. In that instance, the so-called reasonable notice would not be given to traders.
I'm a little confused, Ms. Babshefa. I'm not sure whether you're saying that the state that obtained the derogation can unilaterally give what it considers to be reasonable notice to COTED that it no longer requires the derogation, that is going back to the CET, or whether it is that it is COTED that must decide when the state reverts to the CET.
So, Your Honor, if COTED is performing its functions properly as a monitoring mechanism, it should review derogations to see whether they are still necessary. And in those instances where COTED has not carried out a review, the member state, if it is going back to the CET, should inform COTED, but informing COTED, providing the information so that COTED, as a good administrator, as a regional administrator of the CET, can make sound decisions. But ordinarily, there is in suspensions, there is a time period, or as in Article 149 in relation to, well, derogation is one of the measures, but in relation to Article 146, it said that COTED shall periodically examine the impact of measures with a view to determine their adequacy and establishing a time frame for their discontinuance. So this is the sort, even if this provision is not applicable, this is the sort of monitoring function that COTED should perform in relation to derogations and suspensions to determine their adequacy and establish a time frame for their discontinuance.
Okay, yes. Is there anything else?
Now, you are mentioning Article 146. But that really deals with very different things, I thought. That's about measures to redress disadvantage arising from economic dislocation.
Yes.
And
so,
then quoted
yes,
periodically, that's sub 3, paragraph 3, examine the impact of the measures mentioned in paragraph 2. And those are measures mentioned in this article which may necessarily provide for temporary derogations from rights and obligations set out in the treaty. I think that does not actually applies to the CET. The CET has a special regime which allows not for derogations, although I now understand where that terminology came from, but that deals with either suspensions or
alterations.
Alterations. Your Honor, with all due respect, Article 146 trumps Article 83. Article 146.2 provides, notwithstanding any provisions to the contrary in this treaty. Now, I cannot say. I was trying to get information to find out on what basis Barbados approached.
You have to read further. The measure, notwithstanding any provisions to the contrary in this treaty, the measures mentioned in this article may, when necessary, provide for temporary derogations from rights and obligations set out in the treaty. So what are the measures mentioned in this article?
So the measures, they put effective measures to arrest or mitigate adverse effects on economic activity. So the article starts off, the member states agree, and I'm saying this is possible, I cannot say definitively without information from Barbados to confirm or unless we find something in the Secretariat. But it says here, the member states agree that where economic dislocation arising from the operation of the CSME occurs. And if you look at the record on page 649, Barbados was arguing that it was under severe pressure from the competitive forces unleashed by trade liberalization. And trade liberalization is a fundamental aspect, as Your Honor knows, of the CSME. So what I can say, I cannot say categorically, and I do not want to mislead the court. But at the same time, I do not want the court to strike down the COTED decision of 2001 out of hand as being ultra-virus without there being some certainty as to whether the manufacturing sector of Barbados as a disadvantaged sector entitled, because of this economic dislocation arising from the operation of the SME, whether it entitled Barbados to go to COTED to institute a measure, and the measure in this case was a derogation. And I do agree that derogations are temporary in nature, because trade liberalization and the CET are fundamental principles of community law. And one must not necessarily, might not always be in a position to stipulate a time frame, because at least in the context of Article 146, it is stated that COTED shall periodically examine the impact of the measures with a view to determining their adequacy and establishing a time frame for the discontinuance. And in Article 145, when it speaks of the review of measures by the Community Council, it says the review shall include an examination of relevant programs and support measures in order to determine their efficacy policy as a basis of their termination from participating.
Okay.
So you are saying then that when a state decides that it does not require any measure or any derogation anymore, it will be COTED that will decide whether they are right or not?
No, absolutely not. Absolutely not. Your
So in this
if that were the
case, Barbados decided they didn't need the derogation any longer. Then you're not saying that, okay, but COTED would not agree with that and overrule that decision. I mean, there's a big difference between getting the approval of COTED or notifying COTED. There's a big difference in its effect and its consequences.
Absolutely, Your Honor. And as this court has said in Hummingbird Rice Mills Limited and Suriname and the Caribbean Community in paragraph 47, it is difficult to attain the threshold of a qualified majority vote. And this very case, in getting the 3/4 majority of the membership of the community, has proven very difficult. We have gotten 3/4 of the parties to the revised treaty. We have 10 member states that have indicated that the cement is other hydraulic cement, but there are two we need at least one.
Yeah, we've seen that. We've seen that in the documents submitted.
We sympathize with you.
So I take it that that's the entirety of your oral submissions. We have your written submissions, which of course we will take into account. And if that is all, then maybe we could give you not more than 5 minutes, Mr. Wood, in the event that there is anything that you wish to respond to. Bearing in mind, of course, that we have your written submissions.
Yes. Yes, my lord, I'll do the reply on behalf of Rockhard Cement. Just
yes,
three points in reply.
Yes.
General Counsel for CARICOM mentioned just now Article 146 of the revised treaty, and it is our submission that that article has no relevance in this case, because one has to read Article 146 along with Article 143, which sets out the measures, the appropriate interventions that are to be done. And we will note in paragraph 2 that there is no mention of the CET or any suspension or alteration, and that the measures set out therein have no bearing on the CET. So we submit that these articles are not relevant to the question for determination. We also note that subsection 3 of Article 146 refers to the fact that COTED shall periodically examine the impact of the measures mentioned in paragraph 2 with a view to determining their adequacy and establishing a time frame for their discontinuance. We read that as COTED acting on its own volition, as opposed to a member state returning to COTED and saying, we no longer need the derogation. So in this case, COTED could have looked at the matter, and perhaps maybe in 2010 said, we have looked at the matter and we do not think we need a derogation. That is how we would read subsection 3 if it were to be applicable, which we do not admit. But the fact is that subsection 3 of Article 146 makes it clear that it is a temporary measure in any event. And so we rely on our principal submission that the derogation was a temporary measure, a temporary break from the treaty obligations, and that once the member state determined that it no longer required that derogation, there was no obligation under the treaty for it to seek the approval of COTED. And one can test it this way. Is it that COTED could have disapproved or said no to a member state when the member state comes back and says, I no longer wish the 60% derogation. I wish to return to the 5% rate which has been established for all member states. We submit that in those circumstances, COTED could not reasonably or could not disapprove the state of Barbados returning, reimposing the CET. Just one other thing in relation to Mr. Amore's submission in relation to the fact that the protocol amending Article 83 was done in 2015. The fact is that from 2009, in the case of TCL and Caribbean Community, the court construed Article 83 of the CET and made it very clear that the suspension was something of a temporary nature. And we remind the court that we're referred to paragraph 56 of that decision. And those would be our submissions. Oh, there's one other thing. Mr. Amor also made mention of the fact that there was one of the reasons the COTED's approval was required was because member states needed to, for want of a better word, participate in the decision. But the fact is that the obligation of member states had already have an obligation under Article 82 to maintain and establish the CET. And we do not think it would be reasonable for a member state, as I say, Jamaica, for example, could object to Barbados saying, we wish to return to the CET, when Jamaica would have been applying a lower rate, because Jamaica would be applying the CET. On the issue of, and just to mention that the CET deals with trade to external countries, not trade as between countries within CARICOM. Just to mention in relation to notification, we wish to point the courts to page 416 of the record. It is an annexure to the originating application of Arawak TCL. It is a letter from the permanent secretary. It is dated November 15, 2015. You will recall, Your Honors, that the decision to revert to the CET was taken by Cabinet in October 2015. And in this letter, the permanent secretary, Mrs. Nancy Headley, writes to Mr. Ralph Thorne, QC, who had been writing on behalf of TCL and advised from November 2015 that the Ministry of Finance and Economic Affairs hereby acknowledges the receipt of your letter dated November 13, 2015 on the captioned subject and the concerns expressed in relation to a reduction of the boundaries of duty on cement from 60% to 5%. This is to advise that the Cabinet of Barbados, at its meeting of October 8, 2015, agreed that the rate of duty on other hydraulic cement falling under the tariff number 252390.00 would be reduced from 60% to the common external tariff rate of 5%. It should be noted that this reduction relates specifically to other hydraulic cement, whereas the applicable rate of duty on grey Portland cement remains at 60%. And it is to be noted that this letter was written in November 15, 2015, and that this claim was not filed until 2018. Unless we can be of any further assistance, and those would be our submissions in reply.
Yes, well, thank you very much, Ms. Mayhew. We will take time to give our decision on this matter, but we will make every effort to give it well before the hearing on the classification issue.
Much obliged.
Thank you.
Would rise.